What if a judge orders you to bring your money back from an offshore trust? Hi, this is the Business Guy. Today, we'll navigate the waters of offshore trusts. You've likely heard of offshore trusts, but the burning question is, if a judge orders you to bring the booty or money back, what do you do? The allure of offshore trusts. Did you know that an astonishing 25% of global wealth is stashed offshore? But why? Asset protection, privacy, and perhaps the allure of an island sunset. Number 2, judge's reach versus the deep ocean. A judge might rule the mainland, but overseas, that's a whole different realm. Offshore trusts fall under their own jurisdiction's laws. In other words, U.S. courts don't have jurisdiction over foreign trusts and trustee companies. And in order for a judge to legally hold you in contempt, 3 pieces of prima facie evidence must exist. Number 1, you must hear the order, and you did. You were standing right there. You must understand the order. You speak English, right? And number 3, you must be able to comply with the order. However, when our trustee law firm steps in to protect you, you don't have the ability to comply with the judge's orders. And that's why offshore trusts work. The trustee has discretion not to turn over the money to your legal enemies. Now, you can get the money for your own purposes, but the trustee is not going to turn over the money to anybody other than you when you're asking for it of your own free will. Number 3, the myth of absolute control. Assuming you're the puppet master pulling all of the strings, think again. Many offshore trusts are designated so you don't have direct control. And some people tell me, I want all the control. Well, that may feel good at first blush, but it's also very naive. If you have full control of the money, then the judge can order you to use that control to turn over the money to the courts. So you in control isn't really you in control, is it? You in control equals the judge in control. So in order to really protect your money, it needs to be in the hands of, for example, our trusted law firm / trustee in the Cook Islands. Now imagine this scenario. Your opponent's lawyer says, Your Honor, we demand the money be returned. And then you as the defendant say, I'd love to help, but the trust has a mind of its own. In order to request the money, you must sign an affidavit under penalty of perjury that you're requesting the money of your own free will and not under the duress of the courts. And the courts cannot order you to perjure yourself. Number 4, the duress clause, your hidden dagger. Ever heard of the duress clause? It's like a secret weapon that we insert into every offshore trust that we create. If you're not asking for the money without pressure from an enemy who wants to take it away from you, that is, you're not asking for it under duress, you can get the money anytime you want. Even if someone tries to bring the lawsuit to the jurisdiction where the trust is formed, we can simply move the trust to another jurisdiction. So a Cook Islands trust can become a Nevis trust, which can become a Belize trust. But remember, folks, with great power comes, well, you know the rest. Number 5, the Offshore Trust Olympics. Popular jurisdictions include the Cook Islands, Nevis, and Belize. But it's not about the prettiest beaches, it's about the strongest legal protections. The jurisdiction where your offshore trust is established plays a crucial role. Different countries have varying levels of cooperation with international legal orders. If a judge orders an issue to repatriate your assets, it depends on factors like the location of the trust and the laws of the host country. That's why it's so important to pick the right jurisdiction. My favorites are Cook Islands and Nevis. Number 6, the sticky web of international law. Repatriation is complex. It's like untangling a massive fishing net after a day at sea. Countries have treaties, and these play a role in how decisions are enforced. For example, you can't go into a stranger's house and rearrange the furniture. A judge can't order our foreign trustee law firm what to do. Number 7, offshore, a double-edged sword. Offshore trusts offer protection, but remember, they need to be set up right. A weak foundation, your ship just might sink. That's why it's so important to choose the right organization to set up your international trust. In fact, my firm has set up more Cook Islands trusts than any firm in the world. Number 8, ask the experts, the trustworthy trustees. 90% of offshore trusts get expert help. Don't DIY this. It's a lot more complex than assembling IKEA furniture. Besides, you likely won't be able to do it yourself because our offshore trustees won't work with people. They will only work with professionals such as the attorneys in our firm. Number 9, in conclusion, to trust or not to trust. Navigating the world of offshore trusts is like setting sail on the open seas. Exciting, promising, but you need the right crew and the right map. and maybe a good compass. So I think we've established a clear understanding of what an offshore asset protection trust is. Essentially, it's a legal arrangement where assets are transferred to a trust located in a foreign jurisdiction, often with favorable laws for asset protection. This is done to shield these assets from potential lawsuit, creditors, and other legal risks. So thanks for embarking on this voyage with us. If you found treasure in our content, smash that like button. If you want more free information, visit assetprotectionplanners.com and fill out a free consultation form. We'll see you next time. This is The Business Guy.